Hi, I'm Anant. I work with the dispute and regulatory practice team at Nishith Desai Associates, and I'm based out of the Delhi office. Today, I'm going to talk a little bit about the law relating to corruption and corrupt practices in India. Unlike much of the developed world or the UN Convention, the OECD guidelines, India does not have a comprehensive law on corruption. What we do have is a law called the Prevention of Corruption Act, and we have certain provisions relating to corrupt practices set out in various other ancillary laws, including subordinate legislation like rules and regulation of central government and state government and various other government departments. So to start with, the Prevention of Corruption Act is the principal act. It was created by repealing certain provisions of the Indian Penal Code, and what it does is it prohibits certain acts in relation to public servants, and it primarily prosecutes the act of receiving bribes. So it does not prosecute the offering or giving of a bribe, because there is a provision in the Prevention of Corruption Act which provides immunity to the bribe giver if he cooperates with the authorities. Now, this is one of the principal criticisms of the Act, and people would recall that in 2012, when the spectrum licenses were cancelled by the Supreme Court, the government felt that the Prevention of Corruption Act did not give sufficient teeth to the authorities to prosecute the act of bribe giving as well. One of the objectives of amending the Prevention of Corruption Act was to prosecute the act of bribe giving as well. The other thing that Prevention of Corruption Act did not satisfactorily address, or in fact it did not address at all, was bribes in the context of the private sector. So who can be prosecuted today is only a public servant under the Prevention of Corruption Act, whereas any illegal gratification which is given in a transaction between two private individuals would not be covered by the Prevention of Corruption Act. The Act also is not comprehensive in relation to public procurement, and experience has shown, including the judgment of the Supreme Court in the 2G spectrum case, that India lacks a comprehensive law with respect to public procurement. So the government sought to address all of these deficiencies in an amendment which has been introduced in Rajya Sabha. However, the amendment was referred to a standing committee and later to the Law Commission as well, and the Law Commission has given various recommendations with respect to the proposed amendments to the Prevention of Corruption Act. In India, we don't have a dedicated agency which enforces the law of corruption. Prosecution in relation to corrupt practices is primarily by the Central Bureau of Investigation. Sometimes it may be by the police authorities, the Economic Offences Wing as well. In certain cases, it can also be by the Central Vigilance Commission. But there are certain ancillary departments which look into these transactions. One of them is the Comptroller Auditor General of India. And it is possible that authorities look at reports prepared by Comptroller Auditor General of India, particularly in the context of public procurement. And these reports then become public, and then they become subject matter of discussion. And the reports of the Comptroller Auditor General has been used for the purpose of filing public interest litigations, which can then precipitate into investigation against private individuals as well. The other aspect about corrupt practices law in India is gifts, the giving of gifts to certain individuals, and the issue of political contributions. Giving of gifts is not per se prohibited, subject to certain monetary guidelines and certain reasonable limits. Central government rules and state government rules have permitted the receipt of gifts subject to the monetary limits and subject to disclosures. However, if you are giving gifts to individuals in a department with whom your entity or you are transacting for the purpose of regulatory approvals or anything like that, then in such cases, per se giving of a gift might be prohibited. Political contributions is not prohibited. It is permitted both under the Income Tax Act and the Companies Act. However, it is subject to certain restrictions in both the Companies Act and under the Income Tax Act. As I had mentioned, the really interesting or the exciting part about corrupt law in India is the amendment bill. And as the bill has been pending in the Rajya Sabha for quite some time, everyone is awaiting the fate of that particular bill. We know that Law Commission has given certain findings as well. Now, our international audience might be interested to know how the Prevention of Corruption Act with the amendment stands in relation to international standards. As per the Law Commission report and based on our own analysis, we do believe that the Amendment Act as well doesn't address certain important aspects. These include guidelines necessary for private companies, for companies to follow, which would be considered as sufficient compliance, and by which a company would be able to demonstrate its bona fides. The proposed amendments to the Prevention of Corruption Act has not considered comparable amendments or provisions in the UK Bribery Act. It has also not considered similar standards which are there either in the OECD guidelines or the UN law on the subject of corruption. So before the bill becomes act, it would be important that all of these concerns are addressed. While the amendment will be prosecuting the act of giving of bribes as well, it does not provide for the act of illegal gratification in a private transaction. It may be important to address this issue as well. The other thing is, which the act should provide for, is element of compensation if one party is wrongfully, loss has been caused to it wrongfully as a result of corrupt practices which has been indulged in by another entity, including the government. It is important that some compensatory provision should be there in the statute as well. The government should also be careful that as a result of any corrupt practices indulged in by any of its employees, if a company suffers, that the government should not then suffer the risk of a bilateral investment treaty. So these and several other issues have been addressed in our publication. We've also had opportunity to advise clients with respect to compliance, and some of these issues have been addressed in our publication. Thank you.